Hi, everyone. Welcome to today's webinar. I see that we have people joining, so I'll give everyone a minute to get signed on while I make some opening announcements. I'm Nicole with the San Diego Law Library, and I have here with me today our speakers Melanie Gold and Joanna Schiavone, who will be discussing the anatomy of an appeal. I just have a couple of housekeeping things to do before we get started. First of all, you should have already received a handout for today's webinar. If you have not received the handout, please email refdesk@sdlawlibrary.org and we'll resend the handout. Again, that's refdesk@sdlawlibrary.org. Next, for those of you who are here for CLE credit, this class is for 1 hour of general participatory MCLE credit. We will be issuing a participatory MCLE certificate to those of you who are verified to have attended today. So be looking out in your email for that certificate later today. If you're ending today's session via audio and dialed in using a phone, please send us an email with your name, your phone number, and your bar number in order to receive MCLE certificate. Again, you'll only need to email us your name and bar number and phone number if you're joining us via audio and dialing in. This is also an interactive presentation, so you have the opportunities to submit questions during the presentation for our speakers, but we do ask that you use the Q&A function. Under the Q&A function, you may ask questions either anonymously or with your name, whichever you feel most comfortable with, and we'll try to get to as many questions as possible today. Lastly, you will also receive a link to a survey at the end of the presentation. We really would appreciate any of you who would take the time to complete that survey and give us some feedback on the presentation. And with that, I will turn things over to our speakers, Melanie and Joanna.
Thank you, Nicole. We're so excited to be here today. This is the third time Melanie and I have presented for the Law Library, and we really love this audience and we love sharing insights about appeals. So a little bit about our firm. We're a boutique firm of 25 appellate lawyers throughout the state of California, and this is all we do all day, appeals, and in both state and federal court. And I'm going to let Melanie share a little bit more about her background, and then I'll tell you a little bit more about my background, and then we'll dive right into the content.
Hi, everybody. Thank you so much for coming. I'm now in private civil practice, but for many years I served as an attorney at the 4th District Court of Appeal, and for several years also worked at the California Supreme Court. So I hope to give you some inside and outside perspective to enhance your understanding of the appellate process.
And I'm Joanna Schiavone, and I was a law clerk in the Ninth Circuit almost 2 decades ago. I also did a clerkship in the Central District of California, so I have a perspective from the trial court and the insight that gives you on preserving issues for appeal. And then I've been in private practice for more than 20 years, and I'm a certified appellate specialist. And so Melanie and I are gonna ping off of each other for the various content that we're going to offer today with her deep expertise, particularly on the state side. And I'm going to share some federal perspective with you. And we hope that you have a lot of great takeaways from today. So we did want to spend just a moment on what our goals are. So our goals are to provide an overview of key questions to consider in handling a civil appeal, and to share some expert tips to enhance your practice. But what we can't do is tell you everything about everything for every stage of an appeal in 1 hour. So we're really here to introduce you to some of the key rules of the road, the key phases of an appeal, some issues to flag where people often have difficulties that we'll see where people run into roadblocks or timeliness issues. And then, of course, for all of the rules, statutes, law, and guidance that we're going to provide you today, you should dig further underneath it to see how it applies in your case and if anything needs to be updated. So with that, I'm going to turn it over to Melanie to kick off the first phase of the appeal, the startup phase.
Thank you, Joanna. And I just want to reiterate that we're covering a lot today. Each slide could be a full day's presentation, but it's really helpful to have an overall familiarity with the process and the critical issues. And we're happy to come back and talk about more of the topics in depth. So we're going to start with, you receive an unfavorable ruling. Can and should you appeal? And the first 2 critical questions you have to ask yourself is the ruling appealable? And what is the deadline for filing an appeal? And there's also a form, which I'll show you in a minute. But okay, so the first question is, the next slide too, only, oh yeah. Okay, so only final judgments are appealable. And this is generally the last final ruling in your case. Any order before that is generally not appealable. For example, a lot of attorneys will appeal from a summary judgment order dismissing the case, but that is not appealable. You have to wait for the judgment dismissing it. Also, a frequent issue in this is, what about a minute order? If the minute order is signed and the court does not expressly state there will be a follow-up or assign an attorney to draft up the final judgment, that minute order is a final judgment for purposes of the appeal. So, but even if there's not a final judgment, there are, of course, many exceptions, as there are in law, and it's beyond the scope to discuss these exceptions today, but be aware of these because they're really important. They're generally collateral orders or by statute. Certain orders are appealable. So a detailed list is contained in CCP 904.1, and an excellent resource is the Rudder Group Civil Appeals and Writs Chapter 2B. So you can look at that. The most common are family law orders. If you're in family court, make sure that anytime you get an unfavorable ruling, you check that and see if it's appealable. Also anti-SLAPP rulings and arbitration. The implications are, if an order or judgment is appealable, you must file a timely appeal or forever lose the opportunity to obtain appellate review. So if it's not clear cut, consider filing something right away, because there's generally no harm in filing a premature appeal. So the first question is ruling appealable. The next question is the timing. When is a notice of appeal due? And this is jurisdictional. The court has no power to consider your appeal unless it's timely filed. The court cannot grant relief, no CCP section 473 relief. If you look at the cases under drastic circumstances, there's still no relief. You become unconscious for a week, no, you have a solo practice, no relief. So you have to file it on time. Parties cannot extend. Other appellate deadlines are much more flexible, but this one is not. So when is your notice of appeal due in state court? 60 days if there was service of the judgment, and or 180 days after entry of the judgment, whichever is first. So sometimes the service dates can raise issues and can be complicated because of the drastic circumstances. If you're unsure if there is a service or service date, assume the 60-day appeal deadline is started right when the court has issued the appealable order. There's also extensions for denial of valid post-trial motions. Look at Rule 8.108, California Rules of Court 8.108. There's usually 3 different dates within each of those post-trial orders. So make sure it's the first one of those. So I've seen attorneys mess up and lose their appealable right because they didn't read that statute carefully. Generally, it only is when the post-trial motion was valid, and that does not mean it was meritorious. It's just that if the procedural requirements were followed. So file the notice as soon as possible after the appealable judgment is entered. There's usually nothing to be gained by waiting until the eve of trial. A last-minute appeal will not preclude cross appeals, because then the cross appellant has another 30 days. So the next slide is the notice of appeal. I just wanted to show you, it's a very simple document. It's a 1-page document, and make sure you put all named parties in there and correctly identify the order of judgment. So those are 2 important things that could harm your chances of appealing. Joanna?
Great, Melanie. And we cannot stress this enough, because it is amazing how much litigation there ends up being over whether something is timely. And so I think our biggest takeaway from the timeliness and jurisdictional implications of filing your notice of appeal, whether you're in state or federal court, is do it early. Do it early and be really careful in analyzing whether you have an appealable order. So I'll just do a quick summary to point you to the relevant authorities with respect to a federal notice of appeal. So largely in the Ninth Circuit. I do practice outside the Ninth Circuit, but I'm going to refer to the Ninth Circuit today when I talk about federal appeals. Again, deadlines are jurisdictional. It's Federal Rule of Appellate Procedure 4 that governs this. If you're handling a criminal appeal, we're mostly talking about civil appeals today, but I wanted you to know it's a shorter time to appeal, and so you just need to be aware of that. For a civil appeal, it's 30 days. It's 60 days if the United States is a party, and then the rule has a lot of intricate subparts about what that means, if it's a government head of a government agency, et cetera, et cetera. So you'd want to look at that really closely if there is, if the United States is involved in your litigation. Just like in state court, as Melanie explained, there can be extensions of that deadline for timely filed post-trial motions. So similar to valid post-trial motions in state court, the rule in federal court refers to timely post-trial motions. Post-trial motions in federal court have to be filed within 28 days after entry of judgment, and so it's slightly ahead of the notice of appeal deadline. But then they may extend that deadline for additional time after the court rules on those motions. And then there is, unlike in state court, there is a potential extension of time. It's extremely rare, so I'm not going to spend a lot of time talking about it. But if you were interested in that or are litigating that issue, I've given you the FRAP there so that you can look at what the nuances are for an extension of time. You do that in the district court. And I think one thing we should emphasize, Melanie, I'm not sure if we mentioned it, is when you're starting an appeal, these filings happen in your trial court. That's often a question that we get from trial counsel. You are going to handle that. If you're trial counsel or you're working with trial counsel, they're going to handle it. And so you need to really be watching that closely and working with them. The initial startup phases of an appeal happen in the trial court before they pop up to the appellate court. That's true for both state and federal appeals. And then we're going to talk more about that when we both talk about how you then get the record from the court. That also happens in the trial court. So this is the notice of appeal form for federal court. It's also very simple, as Melanie said with the state court notice of appeal. This is very simple. Again, it's directed to the U.S. District Court for whatever district your federal case is arising out of. And you need to, just as Melanie noted with a state court appeal, you know, it's important to give the court the key dates so it can do a jurisdiction check to make sure that your notice of appeal is timely filed. And to list all of the parties. And if it's a cross appeal, you need to, complete it for purposes of a cross appeal. So with that, I will turn it to Melanie for designating the record, the next piece of the startup phase.
Right. This is the next critical step in the appellate process. In California state courts, it is the party's responsibility to ensure the necessary trial court records and transcripts get to the Court of Appeal. This designation creates the closed universe of documents for the Court of Appeal to consider. And it's not just a procedural requirement. If the court does not have all the relevant records from your designation, it could find and will find your arguments forfeited on appeal. So this is a really critical step, and it does happen in the Superior Court in the beginning because the forms are filed there. So a couple of primary principles. Every factual point in your briefs must be supported by the record that you designate. Second, timing. You have a really short time after the filing the notice of appeal to file a designation of record, 10 days for an appellant. But this deadline is not jurisdictional. If you don't timely file, you will get a notice of default and you can fix it. And if you forget a document, you can fix it later through a motion to augment. But it's really important, as soon as you filed your notice of appeal, to get started on your designation of record in the state court. So third, designating a record can be very cumbersome, and there's forms for that. APP 003 for the appellant and APP 010 for the respondent. These are filed in Superior Court, and the forms are not well written. They're confusing. They ask you to make various choices. I want to talk about one important choice. You have the decision to make as to whether to designate a clerk's transcript or an appendix. A clerk's transcript is a booklet that the clerk's office prepares based on the documents you identify in your form. An appendix is a booklet of trial court documents that you yourself put together and serve when you file your brief. Which should you pick? There's no one right answer, but there's a couple of advantages and disadvantages. Advantages, you don't need to decide right away which documents you'll put in. You file when you file your brief. And the appendix makes the appeal go faster. It can make it go faster because you don't have to wait for the clerk's office. The disadvantage is the flip side, you need to put it together yourself, and it can be complicated to prepare the necessary indexes and to pull all the documents together. So if you're not an experienced appellate practitioner, you might want to think about selecting the clerk's transcript. And if your client has a fee waiver, the clerk's transcript is free. If there's reasons to slow down the appeal, you might want to use the clerk's transcript. What should be designated? By statute, certain documents must be included. That's Rule 8.407. Everything else that's potentially relevant. You must designate both helpful and unhelpful documents. The court of appeal wants to see everything, and it's better to be over-inclusive. And do not put anything in there that wasn't before the trial judge or tried to be before the trial judge. I've seen sanctions being imposed for somebody who's tried to slip that in, because the record of appeal is just what was before the trial court. Don't forget exhibits or lodgements. This is something that often experienced counsel will forget. Reporters' transcripts, I don't have a lot of time, so I'm going to just summarize. Make sure you get them. They're expensive, but make sure you order them right away. If you didn't have a reporter, an agreed statement or a settled statement can substitute. Look at Rule 8.134 and 8.137. So, but reporters' transcripts, I've seen a lot of appeals that were rejected because what happened at the hearing was not before the trial court. It wasn't designated. Joanna?
Okay. And I'll just do some quick highlights. The process is slightly different in the Ninth Circuit, but all the same themes that Melanie articulated apply. What you're going to do to get the transcripts in the district court is you need to submit a transcript order form to the court reporter. So unlike in state court now where you have to, we should just emphasize, if you're trial counsel or you're working with trial counsel, and there's any important hearing, make sure somebody brings a court reporter so that you can actually order that transcript later. That's a really big issue in state court right now. In federal court, that's not as much of an issue because each district judge has their own designated court reporter that transcribes every hearing or reports every hearing. And the magistrate judges, if there's a hearing that's not reported, it's recorded digitally and can be transcribed later. But you have to, there's a form, you need to order the transcripts, and that notice gets sent to the court reporter. They will prepare your transcripts. They're supposed to do it within 30 days, and then they'll file it on the CMECF system in the district court. You then should download all those transcripts, and then you're going to include them yourself. Those won't necessarily go to the Ninth Circuit if you don't include them in what's called your excerpts of record. It's more similar to the appendix process Melanie described in state court, but the excerpts, everyone has to prepare. I gave you the 2 rules here that govern that. The rule requires you to include all material from the record that's relevant and useful to the court in deciding the appeal. And here's my expert tip on preparing excerpts of record. If you read the rule, the Ninth Circuit rule requires you to prepare your excerpts in reverse chronological order, so that you're preparing with the first volume to have the judgment and the critical orders that are on appeal. You have to put those in the first volume. But it's then up to you if you want to, in your case, prepare it actually in chronological order. I often opt to do that in my cases because I think it makes more sense to do it that way in that specific case. So the rule defaults to reverse chron. I use chron most often because then for your transcripts for any hearing, it actually has to be in chron order. So I think the case unfolds better if you go from complaint to the end of the case. So anyway, just look at that rule, Ninth Circuit Rule 31, and you can modify as needed. And then I'm just going to touch briefly on another issue we get a lot of questions about, which is stay of the judgment in the trial court pending appeal. And so here are just a couple of questions that you should be asking yourself. Again, this is a whole probably 2-hour CLE, right, Melanie? But here are some critical questions that you should ask yourself. So if you need a stay pending appeal, consider, is it automatic? So for example, there's certain kinds of injunctions. If it's a mandatory injunction, it would be automatically stayed, but not if it's a prohibitory injunction. So you have to do that analysis. It might be, you might be able to seek a stay by a motion or a writ, or by paying a bond or a security. Again, these issues are complex, but you're going to want to analyze them at the outset of your case. And then another just practice pointer, in state court and in federal court, be courteous with agreeing not to oppose or to stipulate to extensions of time for the briefing schedule in particular. Courts are really busy. We have heard from judges at all level. They don't want to review motions where people haven't even agreed to just the courtesy periods where you can stipulate. Unless there's some real urgent need in your case for it to be resolved sooner, try to be as courteous as you can in agreeing to those. In state court, every brief can be stipulated for at least a 60-day extension by agreement of the parties. You also get default time on top of that for the opening and respondents briefs. I've given you the rule there. I always get questions about whether that is in addition to stipulated time. It is. And then in the Ninth Circuit, you can apply for a streamlined extension, which doesn't even require talking to the other party. 30 days for any brief. It's just a simple form you file in the electronic filing system at the Ninth Circuit. If you think you're going to need more than the 30-day streamlined, though, you should file a motion on good cause in the Ninth. So with that,
Okay,
we're going to
so-
dive into the next phase, the
Right,
briefing
so-
phase.
Right.
Yeah.
So we're now at the briefing stage. I'm just going to take it over because we have so much to tell you. This is your tool to persuade the appellate court to your position, really your only tool. We don't have time to go in depth, but we'll give you some tips on how to approach preparing an appellate brief. First, an appellate brief is not a trial brief. It's not, because an appeal is not a second trial. I can't tell you how many times I've heard justices and court attorneys, after reading an appellate brief, saying this must have been the trial attorney because he or she wants to retry the case. Your brief needs to identify the discrete legal errors under governing review standards and not repeat your trial brief or your trial arguments necessarily. And almost more importantly, there is a very different audience between a trial and appellate court. And I'll just say a couple of the reasons for that and then say the implications. The assigned the justices, there's a 3-panel justices, will know nothing about your case when they pick up the brief. So they will not hear or see from you again until they've made a tentative decision. And in state court of appeal, they will have prepared a polished draft opinion before hearing from you orally. So they will have the written product. Secondly, appellate justices read hundreds and hundreds and hundreds of pages of appellate briefing every week. They remind us of that all the time. Appellate justices are generalists. They do criminal law, family law, complex civil cases, discovery, writs. They do it all. So they may not be an expert and probably are not an expert on your case. Fourth, appellate justices have a professional research attorney to help them scrutinize the briefs, do independent research, and look at the facts that you're citing. And perhaps most important, appellate justices, unlike trial judges, need to prepare a polished, well-reasoned written opinion in every case. So what are the implications from these differences? First, at the appellate stage, information equals persuasion. Write that down if you don't write down anything else. When starting the brief, the justices don't know the law or the facts, but they need to soon decide and write a well-reasoned opinion. And the best thing you can do is help them by giving them information. Be informational rather than argumentative. The goal is to have the justices cut and paste your brief into their opinion. By informing them of the law and how that applies to the facts, you're persuading the court to your position. So for example, if you say something like, for the trial court to have decided that light was green was an outrage and a blatant and outstanding disgrace and made absolutely no sense. You'll never see that in an opinion. That's not informational. Compare that with the undisputed evidence showed the light was red, cite to the record. The court made a factual finding that the light was green. The laws prohibit recovery to a plaintiff driving against a red light. That is going to appear in the opinion if the court agrees with you, if your cites support that. Second, in addition to information, simplicity is the key to persuasiveness. Quoting Justice Roberts, Chief Justice Roberts, quote, you want to take the judge by the hand and take him or her along with you. Don't make the reader reread a sentence. Use plain language, simple words, short sentences, and short paragraphs. The goal is not to make you look smart. It should make the reader, the justice or the research attorney, feel smart. So let's put some of these ideas in more concrete terms by considering introductions. The introduction I think is the most important part of an appellate brief. And why? Because it provides an entryway for the justices to read your brief. Consider two houses next door to each other. One of them has an open door with, you can see the chocolate and then the delicious fruit and flowers, and it's just an easy walk inside. The other one next door is dark. It has a maze to get in. It's very complicated. It would take a long time. And which are you going to go into? So if the justices get lost in what you're trying to say in the introduction and don't want to read your introduction, they will put down the brief and read the other one that doesn't have the maze. So you have completely lost your sole chance to persuade. So what do you do in an introduction? Think of it as spoon feeding. You state in simple and plain language and a concise manner what the case is about, what you're seeking, and why the court should rule in your favor. The fact that your case may be complicated does not preclude you from doing so. So you can, I'll just very quickly tell the story of Justice Froelich. Former Justice Froelich used to tell that he observed an oral argument and the advocate couldn't explain his argument. And then he got into an elevator and a colleague asked him what the case was about. And he said it beautifully in one or two sentences. The same with brief writing and intros. So you can add more. You can, a lot of these fancy classes talk about themes and adding facts and making it sympathetic. You can do all that. But the basic information needs to be in there, simple, short, understandable, no citations, no acronyms. So we're going to look at a few examples very quickly. Some common mistakes, starting in the middle, too lengthy, having a contract style introduction. So let's look at some examples. Okay, so this one, you can see it's very hard to read and it has all caps. It has all these different acronyms or, initials and here and after, all these words that are just like you wouldn't want to read this. And it has like to create, okay, so yeah, so she's moving on there. So the better start is Tree Development Corporation appeals an order adding it as a new defendant to a judgment entered many years ago. Under settled law and undisputed facts, the court had no authority to do so. That's clean, plain. You understand where you're going. You understand what the case is about. Next slide. This one is an actual, many of these are actual things from briefs, but the names are changed. This was an introduction. It's way too detailed. There's no way you're going to be able to get into it. It was a criminal case. Go to the next slide. And I'm going to let you all, you're going to get these slides. You can look at these a little more carefully when you have time. But a jury found defendant committed burglary and identity theft crimes. The court imposed a 15-year sentence. So you didn't have to say what every crime was. The court erred in denying defendant's motion to suppress. The police officers based their search on stale information obtained almost 1 year ago. So that's like, it's putting a question there under Supreme Court authority. The search was unconstitutional. Okay, so that's clear. It's powerful. Go to the next slide. I'm just going to talk about this for 1 minute. The next slide. If this is an example of flopping the court in the middle of the case. If you read it, starts talking about easements and all this stuff, you don't know what this case is about, why they're saying you should fail. This case was about two Rancho Santa Fe neighbors who were fighting over a little tiny piece of an easement, something that was between their property and who should use it. And it was a jury trial, and the arguments were about evidentiary and instructional errors. Say that, get the court interested in what the case is about. Put this much later about the specific arguments and don't plop the court in the middle. The next one, the next slide is, this is a contract style of introduction. Look at that, it's very unhelpful. Go to the next one. This is one that's talking about respondent's brief permeated by overt misrepresentations, patent misstatements, plethora of logical fallacies. There's argumentation ad hominem. Yes, they know that you took a Latin class, but there's no information in here, and the justices will not find this helpful, and it's not specific, and it also has language that's not easy to read, and you're not making the judge feel smart. Okay, so this one is, you can do it creatively. So this is a good one. With apologies to Dorothy and Toto, we don't appear to be in California anymore. Courtesy of Motor Corporation's writ petition, we have been transported to a dreamlike world in which law and facts are so distorted as to be almost unrecognizable. And it goes on and it kind of says what the issue is about between class actions and private attorney general. This was actually written by a current justice at the Court of Appeal who, when he was an attorney, and he says that it was very successful. But it's, you know, you have to be careful if you're making kind of trying to be not funny but clever, but still you can be clever, creative, but say the basics and make it clear for the court.
Okay, thank you, Melanie. All right, so she
And
also has some other slides.
I'm just going to say one
approving
thing
the
about the statement of facts. The
Yeah.
only thing, we don't have time today, but I'm just saying one thing. Be objective. Don't argue in the statement of facts in that section of the brief. That's all I'm going to say.
That's a very good tip. Okay, and she gave you some examples on improving the story for your statement of facts, so you can look at those when you go back to the, we knew that the font was going to be small today, so you can go back to those in the written materials. And then I'm going to give you just a couple of add-on tips for your briefing. And if you came to a previous session, Melanie and I you will have heard me talk about the importance of a table of contents. I think that was 2 years ago, and I have now been at multiple sessions where this came up from both state judges, justices, and Ninth Circuit judges, where they talk about how important the table of contents is. Think of it as a roadmap, and I'm going to show you why that is. I want you to consider the reading pattern. More and more judges and justices are reading everything electronically. They have an iPad or on their computer. And so we really need to be attuned to how people read on the page electronically. I'm going to show you a couple of the most common reading patterns and give you some examples. I'm going to share with you what I think are some style choices that affect readability, and I'll illustrate those for you. And then I'm going to touch on what are the 3 pillars of an effective argument, and all of them require civility. And that touches on what Melanie pointed out about, you know, some of the language choices that you can make. It's really important to exercise civility in order to be persuasive. Your goal is to win. So, table of contents as a roadmap. So the table of contents should tell the story of your brief. Many judges and law clerks or research attorneys are going to read this first. I know that that was my practice when I clerked for 2 different judges. I've heard many judges say this. And so as you are writing your brief, have the styles applied in your Word document and then pull them into a table of contents and consistently be reading that table of contents to ensure it provides a solid roadmap for your case as you are crafting all of your headings and subheadings. I'm going to show you what that looks like. In this case, it was about contractual attorney's fees. Many of you will recognize the statute, Civil Code Section 1717. So this is an excerpt from our table of contents for the argument page, or the argument section. So this first Roman numeral 1, Civil Code Section 1717, does not authorize an interim award of attorney's fees. A fee award under the statute must await final disposition of all claims between the parties. The court knows exactly what our argument is based on that Roman heading. And then if you read each of the subheadings under that, they're very specific in making an argument and presenting what that argument is. So the court, after looking at this, it doesn't just say argument, you know, Civil Code section, you know, the Superior Court's attorney fee award was incorrect. End. That doesn't tell the court anything about why we were challenging as the appellant, why we were challenging the interim fee award. So we have said a fee award must await final disposition of all claims between the parties. And then we broke out in the subheadings each of the arguments that would support that under the statute. So that's what I mean by a roadmap. You can read this and know exactly what the factual and legal story is that you will be presented in the following pages. And the court can then quickly determine the utility, frankly, of, okay, I think this is going to be a useful brief in terms of how well it's laid out, how it's structured, and it's already very clear. As Melanie was saying, if your table of contents and then your introduction are not helpful to the court, neutral in describing what's at stake in the case, the court may very well go to the next party's brief. They may not focus on your brief. They may skip to the other party in order to get a useful roadmap. I'm going to talk next about how people read electronic content. So I've been in a number of sessions learning more and more about the importance of this. And so I've given you these two sort of key articles that I would suggest that you read as more and more of us are doing everything electronically. The Ninth Circuit still requires you to send paper copies of the briefs, but the judges really, especially with 18 new judges out of 29 in the last 10 years on that court, they are newer and younger members of the court. They are reading on iPads or whatever their electronic tablet is. I think the same is true in the Court of Appeal, that things are done electronically now. So you need to understand the F-shaped pattern and the Z-shaped pattern. And a lot of this comes out of science, watching people's eyes and tracking eye movements for people as they read on a screen. And so you can follow here what the F-shaped pattern is, 1 to 2, 3 to 4 to 5. So you see the words that are getting the most bang for the buck and the most understanding on every single page are in the top left corner. And then you're moving from left to right. And then the things that are getting the least amount of attention are things that are in the bottom right corner. That is what the data shows about eye tracking movements for an F-shaped pattern. So if you have your key language, your key point you're going to make, you may want to be paying attention to how your final brief turns out and make sure that that heading and that argument is in points 1 and 2 and isn't falling on the page in the bottom right corner where someone who's reading quickly on an electronic page is less likely to see or absorb that information. The other reading pattern is common reading, eye tracking reading pattern is the Z pattern, where people kind of skim. It's more of a skimming reading pattern that as more and more of us digest things, whether it's web content or electronic briefs, people are skimming. And so you need to be aware, even if they make it to quadrant 4 in the Z pattern, it's still getting the least amount of attention and understanding and synthesis, and your eyes are tired at the end of that page. And so it's really important. I'm going to give you some examples so you can see what I mean about looking at every single page of your brief and making sure that you are getting the highest impact out of every page in your brief. And so I'm going to show you some examples, but first I'm going to talk about some things that will enhance your readability. So again, making choices with the reader in mind. Choose a readable font. And I'm going to show you some examples that I think don't serve that point versus some that do. Use headings and subheadings, not just to serve as a roadmap in your table of contents, but on the page, they help break up that page. It helps people's eye tracking actually start over on the page. And you're going to get, again, more understanding, more of the content of your briefs read if the eyes have things that break up each electronic page. Bolding and italicizing keywords, using them sparsely. You'll notice that in judicial opinions, the italics is used for emphasis, but it's used sparsely. I would avoid all caps for all the reasons Melanie just said. Judges often say it seems like you're yelling at them when you have things in all caps. So I would use bold, italics. Some people use underline. You don't need to use all three. They're getting that you're trying to emphasize something, but I would avoid all caps. Look again at each page strategically and consider the white space on the page. Think about that F pattern or the Z pattern and how you're using white space on your page to give people's eyes a rest. And then again, don't forget formatting and Blue Book versus California Style Manual. You'll always hear me talk about this. Your goal is to make the job of the reader easier. As Melanie said, you don't want to create hurdles for the reader. In federal court, the standard is the Blue Book. Use the Blue Book and cite properly. In state court, you're permitted to use either Blue Book or California Style Manual. Use the California Style Manual. They all use it. So what your goal is to have a brief prepared that they can then use, trust, and use in their writing. And if they have to convert your citations and everything from Blue Book style in state court into California Style Manual, you've made their job harder. So I would say make the job easier of everyone on the receiving end of all of your work product. That's my 2 cents. Here is an example of what I think is a readable page. The next 3 examples all have one page just screenshotted. So they're all equivalent amounts of real estate on the page of a brief. So you can see here, this has a heading that was, is specific in terms of it lays out the standard of review. The district court did not clearly err, so clear error is the standard of review. did not clearly err in finding that Dexon failed to rebut the presumption of irreparable harm. So we've articulated that it's the other side's burden to rebut a presumption, and that Cisco independently established its harm. So we've given the court 2 reasons why we should win in that one heading. It's a 1 paragraph explanation of what that introduction to that argument is. And then we have a subheading, again, that's a roadmap. So for this bottom right corner where somebody's eye may have drifted away from it, you can see the page is structured so the subheading is there that keeps the reader engaged and broke up by using white space so that they are going to actually read that subheading. The district court did not clearly err in finding that Cisco timely sought the injunction. So if you just take a quick snapshot and look at that page, you understand where the text is. We have not put too much, in my view, a text on that page. The next page, is this helpful? I think it's less helpful. The font is instead, this one uses Century School Book. This one uses Times New Roman, which many people use, but I think actually all the data says it's harder to read because the letters are closer together and they're taller and skinnier. So I'll let you be the judge of that. But the point here is that you can tell that this agreement to arbitrate is really important, but it's in the middle of the page. It's in a congested quote that's very dense. It's bolded. A lot of it's in all caps, and you just do your eyes glaze over, my eyes glaze over, right? So think about every page, and was there a better way that if there was key piece of this language about this arbitration provision, could they have pulled it out and had it in text sentences? Was there a different way to space or stage this case so that it wasn't so overwhelming and exhausting to the eye? I just think it's a less effective way or less readable. Here's another example of less readable. This is not bolded and not a dense quote, but if you look at this main paragraph that's on this page in the middle, it is 1 sentence. It is 1 sentence, but it then has just a lot of cases that have a lot of parentheticals. And it's 1 giant paragraph that's mostly parentheticals without breaking it up, without much white space. And so my point here is go back and spend some time looking at each page and how you're breaking up. Maybe what they could have done here is end this paragraph sooner. And then actually in the part where it said the court held that the evidence submitted, maybe that's a new paragraph. Your point is you're trying to keep people's eyes from just glazing and scanning and missing the important parts of each sentence on your page. And then my last piece here, it touches a little bit on civility. The 3 pillars of a persuasive argument. You have ethos, which is the ethical appeal, logos, which is the logical appeal, and pathos, the emotional appeal. I think the law library also has sent you an article that I wrote about this a couple of years ago, and now civility is a required whole other hour of CLE for each of us in California. But the point here is that you're trying to establish credibility. You're trying to lay out a legal and policy argument that supports your case. You want to win. And you're trying to convey to the court that the story and the equities and that there is a just outcome here in service of whatever whichever side you are arguing should win. If you are being uncivil in the way that you write your case, you are undermining yourself at each of those stages. You will come off as less credible. Your legal argument will have less persuasive effect, and you will not be serving the court thinking the equities are in your favor. What I mean is, Melanie talked about not attacking the trial judge. Don't attack the trial judge using inflammatory language. Don't attack opposing counsel or the other parties using inflammatory language. Hyperbole doesn't help you. Invective doesn't help you. You can use vivid language without being uncivil to the other side. And if you really spend time to think about each of these 3 legs of the stool, they all require compelling, persuasive, factual, and legal argument, but they don't require incivility. Okay, so now we're going to turn to the next phase. So you've submitted your briefs. You are ready for oral argument, assuming that you've elected oral argument in state court, and assuming the Ninth Circuit wants you to come for oral argument. It's their decision to whether or not to have a case argued. We wanted to just talk briefly, give you an inside view about some things that may affect oral argument in the way that courts actually prepare. So in California courts, and I think Melanie's going to talk a little bit more about this, but in California courts, they front load their work. So research attorneys and the justices have a draft opinion already circulated among the panel before they come into oral argument. And they have not pre-conferenced about the case. So they have a draft, but I don't think that they've pre-conferenced. Maybe they've exchanged some questions back and forth, and Melanie can weigh in about that. But in the Ninth Circuit, it's a completely different process. In the Ninth Circuit, the only thing the judges have shared that point in the case is a bench memo written by a law clerk. It's a neutral bench memo recommending an outcome. There's no draft opinion, and they haven't done any kind of pre-conference in state court either. So Melanie, do you want to talk a little more about what that front-loaded process is like in state court?
Well, do you want to just finish the mechanics and then I'll get to mine? Or are you done?
Sure.
Are you done with okay.
Yeah, so notification timelines really briefly in state court, or at least in the 4th District, Division 1 down in San Diego, you typically are going to get a notice asking if you want to request oral argument right after the respondent's brief is filed, but your argument probably right now isn't going to get scheduled for at least another few months. I would say estimating 4 to 6 months unless you get priority. In the Ninth Circuit, you'll get about a 10-week, and then you get about a 3 to 4 week heads up in the state court when they're setting argument. And you will know who your panel is at that time, although it's subject to change. In the Ninth Circuit, you will have about a 10-week heads up. And what I mean by that is they will send you an email saying, we're considering it for dates 10 weeks from now, in April, May, or June with the following dates. Speak now or forever hold your peace if you have a conflict on any of these dates. And then you respond and you say, I have a conflict on the following dates, but I can appear on the following dates. And then all the parties do that, and the clerk's office will go back and find a date that works for the panel and all of the lawyers, and then they will schedule it. And you'll have at least, I think you get that then the notice the date about 10 weeks ahead. So you're going to get the preview months and months ahead. You won't know who the panel is going to be until the week before your argument, though. And that's for, the court has made a decision that it's not going to reveal the identities of the panel. So your briefing's already done. Mostly you're prepared for oral argument, but you might be doing a few last minute things to argue to specific judges on the panel. Courtrooms and technology. The Ninth Circuit has a YouTube site. I would say watch arguments that your panel, and you can see how the judges interact with each other, or at least try to watch some arguments with some of your judges if you can. Same thing with the state courts are now live casting their arguments. You could actually just go down and watch the argument in person, sit in the back and see how the panelists interact. And so that's what I mean, do some homework. I think it's a really good idea to get a sense of the courtroom. Which side do you sit on? How does the podium work? You can learn all of that by going ahead of time so that you're less stressed on the day of argument. Melanie, back to you.
Okay, so I was asked to kind of say, I've seen hundreds of oral arguments or thousands. So I was asked to kind of, make some observations, quick ones. But yes, when they go into oral argument, there is a prepared, very polished opinion, which sometimes will be filed the next day. So sometimes there is discussions before that, but it's very, very looks like an opinion, which is important to know as an advocate. But one thing is, if you're an appellant, I would definitely ask for oral argument. It's the one time that you get to find out what their issues are. And then you ensure that they are going to talk to each other. If it's waived, you can waive it also, but it could be all in writing. And if they're preparing for oral argument, you're ensuring that I think, this is not official from them, but there's more official attention, not official, but there's more attention put to the case. So I would, if you're an appellant, if you're respondent and you have a really good brief and the appellant brief's bad, I would consider waiving because there's no need to put more attention to that. So I'm thinking about when usually 90%, 80%, although now with new justices, there's a lot more discussion after oral argument. So there is more changes that are occurring definitely in the last 3 years. But I would say a couple of the things when I think about when things have changed. One is style, and substance matters, but being confident, conversational, not reading, that is super important in getting the justices to listen to you. So even if you may be nervous, practice and just have a confident conversational style. Secondly, show respect, know when to back off, because They have that opinion, you know, and if they're arguing with you, you can try, but at some point you need to back off. And the reason is two, you're not going to be convincing them if they keep coming back to you, but more importantly, you have a reputation and they remember you. And if you are somebody who they see as, you know, not being courteous and respectful, the next time you come, they will remember that. So back off and Joanna, I think we'll talk about this, try a different angle. Appellants, I've seen the best outcomes is say it a different, be prepared to say an issue a different way or for a different angle so that you are getting the court to think a little bit differently about it. And I've heard many times, why didn't they say that in their briefs? If they had presented it that way, I would have been more convinced. Now they already have an opinion. If they're going to change the opinion, and they have a conveyor belt of cases. So if they're going to change opinion, it's going to take them more time. They're not going to be inclined to do it. So in the brief, it's better to do that, but say it in a different way and from a different angle. And the other thing is cases that are changed is when they are misunderstanding the facts, and that could be because it's really the research attorney that is looking at the factual record more closely. They will change. They will say, we got it wrong. So we need to figure this out again. So be very prepared on your factual record. Respondents, the biggest mistake is listening. The panel is asking questions about an element and, just really honing in on that. And then the respondent will get up and just start talking about something completely different. And so when we come back, when the justice comes back to the chambers, you say, why didn't they affirm what we were saying? Like, you get nervous, like, are we right? Did they think we were right? I don't know why respondents don't do that. I think because they're prepared on something and they're not listening. So the most important thing you can do is listen, and also don't get overconfident. The fact that the panel is asking a lot of questions to the appellant doesn't mean that they're going to go your way, that you have to don't just say, oh, well, I'm here to answer questions. Have a response, and so don't get overconfident. So those are my quick thoughts on that.
And so I'll just expand on a few of the concepts that Melanie articulated. When you're preparing for oral argument as an advocate, so I've done more than 40 arguments at this point, and have learned learned some tricks and rules of the road. I think having a moot argument is so helpful. So if you can, even if it's a small case with a small budget, maybe you can get some other attorneys. Maybe you have a moot with your spouse. But practice saying things out loud. Practice having people ask you tough questions. It's really different to answer them out loud than to just be answering them on note cards or in your own head. I think it's important to have an opening pitch and not so much memorize so that you sound robotic, but something to get out your first 30 seconds. It's probably when you're going to be the most nervous. Until I know that I'm nervous until I get that first question from the panel, and then I sort of relax into the argument. But I want to be really solid in my opening pitch. I actually have the whole thing typed out in case I blank out at the podium. I have the whole thing typed out. I don't read it. I try to just, I've done it enough times, practiced it enough times that I know it, but it's there as sort of a safety measure in case something happens and I need to go back to it, or in case something, I had one case where the other side didn't show up. And so I was the respondent, and suddenly I had to stand up and talk first. So I was a little more nervous in that case than I normally would have been, where I would have gotten to wait for the other side. So I was glad that I had my opening statement ready to go. I think it's important to have a mantra. And when I say a mantra, it's sort of repeating the point about why you win. And what that does is it's something that you can continually fall back on when you're trying to have a conversation. Now, when I'm talking about answering tough questions, though, as Melanie said, it just means they're interested in the case, right? So don't take it personally. Even if you feel like you're getting hostility from the bench, do not return in kind. I think the four most important steps that you can train on are to listen to the question, pause. And when you pause, I think it's important to breathe. I actually saw someone faint at the podium. So you want to be sure that you're eating before the session, that you're hydrated, and that you breathe during the session, because more oxygen is going to give you more stamina to answer the question. So listen to the question, pause and breathe, answer the question they asked you, and then pivot to your mantra or your affirmative point. One of the biggest mistakes that I see advocates make is not to answer the question that was asked. So if they pose a hypothetical, the answer shouldn't be, that's not our case. The judges, the justices know that that's not your case. That's why they've asked you a hypothetical. But if you want to find a way to say yes, no, or it depends, and then you pivot to your affirmative point about where the limitations of that hypothetical might be and why you should still prevail in your case, that's an effective answer to a tough question. If they ask you a question you don't think is actually the most relevant, don't say that's not the important point here. I have seen many advocates do that from the podium. I have seen judges and justices get really frustrated when that is the answer. Instead, answer the question to the best of your ability, point to the record, and then pivot to your affirmative point. So again, just take it as a good sign if they're asking you tough questions, and try to engage in a conversation with the court. Those are the very best arguments. Okay, now we're going to just spend a few minutes on the decision stage to tell you what's happening.
Yeah, I think we should skip this and go to the next one because we have very short amount of time.
So I'll just give some insights then really quickly. What's happening behind the scenes? What's happening behind the scenes in California court? As Melanie said, they have a draft opinion. They're going to leave the bench after hearing a number of our cases argued. They're going to discuss it, and maybe they would pause on your case and want to go back and modify the draft. Maybe they wouldn't. You will have a decision within 90 days of that oral argument because as long as the case is submitted. In the Ninth Circuit, what happens behind the scenes is they're getting together and pre-caucusing for the very first time. They're going to go back and have what they call a conference, and then they're going to take a vote. And the senior most judge who's in the majority of that vote is going to assign the writing responsibility for that decision. It may be a memorandum disposition, and that's an unpublished decision. It could come out within a week or two of the argument if it's unpublished. If it's a published opinion, we just got one in a case last week where the case was argued last summer. So it took more than 6 months for the court to issue a published opinion. There is no 90-day timeline in federal court. So when you're advising your clients, you can just say it's really open-ended, but it could take 6 months or to a year to get a published opinion.
Okay, so on the petitions for rehearing, I'm not going to go over the timing. Look at that rule because there's a short amount of time. Practical considerations, when each petition is distributed to each panel member, each justice, at least in the 4th District, it gets put on the top of the pile. When they open up the petition, they're like, uh-oh, what did I do wrong? But they're strongly, of course, inclined to deny, and they probably will deny 95% of them. What happens more frequently is if you raise and say that they didn't address an issue, that is something that they will modify. They generally won't because they feel like they've already went through the whole case, decided it, but they may add something to the opinion to address it, and they probably will. Or if the court ruled on an unbriefed issue, that's another fertile ground for a rehearing petition. And I've been involved in one case where there was a grant, and it was where there was a standard of review that the court had gotten wrong, and we realized that, and so we granted the rehearing and had more briefing on whether under that standard of review there was error. So that it doesn't happen very often. So, but the one thing I wanted to say is if you're going to be petitioning to the Supreme Court, which I'll talk about in a minute, you have to preserve, if there's a fact that you think is wrong, you have to raise that in a petition for rehearing in the Court of Appeal. If you don't, you've waived any argument about that. So at the California Supreme Court, after the petition for rehearing was denied, you can look at the deadlines, very rarely granted, less than 5%, probably more like 2%. When you're preparing your petition, look at whether there was error is not the central thing. The court does not care about that. I mean, they care, but it's not going to move them. It's about is there a conflict in the Court of Appeal, or do they need to settle an important question of law? And that's local rule of court. I mean, Rule of Court 8.500, that those are contained in there. An insider tip, the court is looking for a proper vehicle. So if you, it's a messy record, lots of procedural issues, even if it's a good issue, the court may not take it. Also, the court looks, in terms of the vehicle, looks at the quality of the briefing. So because they want to make sure that the merits briefs are going to be helpful on the big issue. So they will look at that. So don't slap your petition for review in the Supreme Court together. Really strongly advise to consult with an expert to help you prepare the petition. So, and it's just much more likely, if you're not experienced, to get the court to grant the petition for review. And be concise in the petition for review.
And I just want to flag for you, similar to what Melanie flagged about post-appeal issues in the state courts, there's also a rehearing process in the Ninth Circuit and a rehearing on banc. Panel rehearing is if you think the three-judge panel made an error of fact and law. En banc is if you think there's some issue that needs to go to the larger court. It will be a majority of the active judges hearing those cases or voting on them. That's where you have an inter-circuit conflict or an intra-circuit conflict. So the Ninth Circuit is either inconsistent with itself, or it issues an opinion that conflicts with another circuit, or doesn't follow the Supreme Court. En banc is very rarely granted. I think in 2024, they only had, I think there were 24 cases that went to call, and I think only 9 actually went en banc. And so it's pretty rare, but if you think that your case qualifies under the rule, I would pursue it. It could help set up U.S. Supreme Court review. I've given you the rules here for U.S. Supreme Court review. It is federal focus. So if you're coming from the state court system and you think this is a case that may go for, may merit federal review, make sure that you're preserving and federalizing the issues along the way. And then there's a 90-day deadline to file your cert petition, so make sure that you have everything calendared correctly for that. And the closing issue we wanted to flag for you is something a lot of lawyers, especially if they don't routinely handle appeals, they forget that if you win on appeal, and if the case qualifies for attorney's fees below, so let's say you have a contract or you have a statute that would allow for fees, you can apply for appellate fees. I had that come up in a case where I won an appeal in the 4th Appellate District a few years ago, and there happened to be a specific statute that allowed for recovery at the trial court level. And after we were the appellant and we won on appeal and it went back, then there was litigation over the fee motion, and we applied for all of and were granted all of our appellate fees. So don't overlook that. It's still rare. The regular American rule still mostly governs that each side pays their attorney's fees. But if you have some hook in the trial court, remember to review the law and see if you can get a hook for prevailing on appeal. And then I gave you some of the citations there. On the same token of that, don't file frivolous appeals, because you could get hit with either sanctions or fees if you are litigating frivolous appeals. And so I've listed the statutes and rules for you there. I see that we have a couple questions, and I think Nicole was going to address those questions. We're a few minutes over, but if you want to hang with us and you want to get your question answered, Melanie and I will be here, and we're happy to answer them. So Nicole, you want to let us know what people are interested in?
Yeah, so starting off, we have just a couple. Some of them are compliments as well. So the first one, it says the California Rules of Court seem to contemplate having trial exhibits sent separately from an appellate's appendix, although the rules also mention transmitting the exhibits if they are not already in the appendix. So what is the better procedure? Trial exhibits with the appendix or separately?
Okay, so the trial exhibits, I think the best way, if you're doing an appendix, is to include them in the appendix. Mm-hmm. Equally, you can also, lodge them with the court when you file your brief, but it's just efficient and easy to put them in the appellate appendix. Was that the question? That was the question. Okay.
Someone asked what percentage of appeals are successful?
I'll answer for the 4th district, and you want to answer for the 9th. I mean, for the state courts of appeal on civil, it's about 17% are successful, and it depends. If you're arguing about like a summary judgment and demurs, they're much higher. And if they're if it's a kind of a factual issue or after a trial, it's much lower. Joanna.
Yeah, it's slightly lower in the Ninth Circuit in civil appeals, but it hovers, somewhere between 15 and 20% success rate in civil appeals. The Ninth Circuit publishes an annual report every year that does a review of that, and so you can break that out by civil cases. And I'll echo Melanie's point. A lot of that depends on standard of review, and if the law library wants to invite us back, I'm sure we could do a whole CLE on that because the likelihood of success on appeal often is based on what standard of review you're arguing under. If it's de novo, it's much higher chances. If you're arguing an abuse of discretion or factual issues that are subject to substantial evidence review or clear error, it's really an uphill battle. And so you have to be strategic in framing those issues.
Okay, and then the last question that we got, the rest are compliments. Somebody said, should you use a question presented before the introduction? And is the introduction only supposed to be about a paragraph long?
I'll answer that for the state. You do not have to put a question presented, and that's not used, and it's very rare, and I wouldn't suggest that. The second part of it is, should it be a paragraph? It'd be great to be a paragraph, but usually it might need more. Sometimes that's all you need, but it could be a page. Just don't go several pages long. It's not helpful, so a paragraph is good, a page is good, depending on how complicated your appeal is.
For the
Okay,
Ninth
and then-
Circuit, yeah, for the Ninth Circuit, it's slightly different. You do have to include in your, if it's an opening brief, you do have to include a statement of the issues presented. And so you have to read the rules as to what's required in a brief, and that is required. And you're supposed to state the issues neutrally, but you want to think about, again, framing them in a light that's going to be helpful to your ultimate arguments. You're also required to have both a summary of argument and an argument. I think all of that's redundant but you're not required to have an introduction. So here's my pro tip. I will often label it introduction and summary of argument. And that way I have included the section that's required. It's up front and I've covered all my bases, but I'm not then feel like I've said the same thing 3 times. I've only said the same thing twice. The introduction, I think my rule of thumb is no more than 2 pages. I think a paragraph is great. 2 paragraphs would be great, but you definitely don't want to be longer than 2 pages if you can help it.
Right.
And then just real quick, I just wanted to let you know that the compliments that you guys received, somebody said that the presenters and content are exceptional and very helpful. Somebody said it was an action-packed seminar full of very helpful information and said thank you. And then lastly, one person said it was the best CLE they ever attended.
Oh, wow.
Wow. Okay, well, you have our contact information. So if you have
Yes.
further questions, you can feel free to reach out.
Yes.
No.
We have, feel free to contact us. We do consulting work also, but also there is a website, a self-help website on the Court of Appeals, California Court of Appeals new website, and it's very helpful if you've never brought an appeal. It has a lot of videos and a lot of step-by-step guidance, and also having somebody in your team, at least consulting or representing it, it's very helpful.
Okay, and with that, I just want to say thank you so much to our speakers, Melanie and Joanna, for such an interesting MCLE presentation. Thank you for all the participants who have attended today. And again, I just wanted to say a reminder that you will be receiving a link to a survey at the end of this presentation. Like I said before, we would greatly appreciate anyone who took the time to answer that survey. And again, thank you to our speakers.
Thank you. It's a pleasure being here.
Bye, everyone.